Awesome. Well, thank you guys for attending today's webinar. We're super excited to be kicking it off. My name is Gavin Merwin. I'm the Chief Technology Officer of the YAS platform. And today, super excited to be joined by Tim Cochran and Cory Kirby for a back to school legislative updates. Obviously, very appreciative to these guys for hopping on with us and co-hosting, co-sponsoring. If you aren't familiar, just a little bit about YAS, and then I promise I'm not going to talk about it anymore. But YAS is Georgia's leading HRMS platform. We currently work with about half of school districts in Georgia. We're a Georgia-based company, things like absence management, timekeeping, recruitment, hiring, some payroll functionality, things of that nature. When you registered, you should have got some information about YAS, and I know a lot of people on today already use it. Feel free to book some time with us to talk more about it. Tim, I'm going to turn it over to you guys, and I'm here to monitor the Q&A and facilitate. If you need anything, certainly just let me know, but you guys have the floor.
All right, guys. Welcome aboard to this first inaugural webinar podcast with Cory and Tim. We don't know if this is the first and last or just the first of many, but a lot of times that'll be based off y'all's feedback and what y'all want. We do want to thank Gavin and the YAS team. They're great sponsors of Pioneer RESA, and they offered to sponsor this webinar for us. So again, thanks so much for those guys. They do a great job, and we appreciate the partnership with Pioneer RESA. As he said, I'm Tim Cochran, Director at Pioneer RESA, and this is Cory Kirby.
If you didn't notice, he's wearing his name tag.
I'm wearing the name tag to make sure y'all know who I am. So, but if you do have questions, there's a lot of people on the call. There's supposed to be, we're at 200 right now. So don't hesitate to put questions in the chat. If we don't get to all of them today, we'll follow up with you through an email or something of that nature. We'll try to make sure we get them all answered. And it may be a case where it gives us an idea of what we might need to go in more detail on in a future webinar. So
we really would like this to be more about the information that you want, the questions that you have, as opposed to just Tim and I up here talking about things that we find interesting or somewhat humorous. So please, by all means, make sure if you have a question, you put it in the chat or let Gavin know so that we can try to answer it.
So there's a lot of legal things that, of course, every year is filled with new legal new laws that you guys that have to do things with, and it can get a little overwhelming. There's a lot that's come through in the last 2 years, really. Mm-hmm. So what we're going to do today is we're just going to try to hit some of the high points, the things that are maybe pressing right now or in the next 6 months. We're going to talk about it. Cory's going to go into detail. I'll kind of give more of a practical approach if need be. And so, and like I said, you guys feel free to throw anything in the chat. But we'll start off, Cory. There was a law passed about revising the personal leave policy. To my knowledge, that was supposed to be done by July 1, and also revising the maternal leave 3 weeks. You want to talk a little bit about that?
Sure. That's one of the things that we've been recommending that needs to be done sooner rather than later. If it hasn't been done, by all means, we need to go ahead and address that. Your leave policies, the board's policies, need to be revised. And we'll start with the leave policy and go from there. But you need to make sure you revise your leave policies. Sometimes districts have employee handbooks and things that they provide both new employees and current employees. Don't forget to address those documents as well. I don't want there to be a situation where in the policy we talk about having 5 personal leave days, but in our handbook it only says 3. One of the things one of the questions that I've been asked a lot, and I don't know, Tim, if you've had the same question, but if that means that they get additional 2 days, it doesn't actually mean you get an additional 2 days. What it means is we take an additional 2 days of your sick leave and allow you to use those for personal reasons as opposed to sick reasons.
Under the old statute, you get 12 days a year. If you're a 10-month employee, of those 12, 3 were able to be used as personal. Now that goes to 5, so no additional days on that.
I do like this from a standpoint of morale, and our educators need to have an opportunity to have a little bit more time. And the reason why, quite candidly, Tim, is because I talked to my wife, and it was a big thing for her. We are in the age group right now where we're having to not only monitor and take care of our kids, but now our parents are coming there. So that gives her a little bit of extra time to do that. But I see it as a benefit for educators. And hopefully that's something that will be maintained. You did mention paid maternal birth leave.
Right. Let's talk about that.
That is a very, very, very new, separate, and distinct type of leave. It is not to be used in conjunction with paid parental leave, but it can be used in conjunction with and simultaneously with family medical leave. And in fact, if I were a superintendent and was coming up with this, one of the things I would want to do in my policy is make sure that maternal birth leave and FMLA leave are taken concurrently, so that we don't have the stacking issue that we could have. Maternal birth leave, as it says and as it sounds, is only going to be for those individuals who actually give birth. So unlike paid parental leave, which can be for both men and women, maternal birth leave is just for women, at least as far as I know, unless modern science has done something different.
Just for women.
That's going to be something that's going to take a little bit of time to explain to your male employees that they don't get this 3 weeks worth of leave that the women will get. One of the other things that you need to understand with this is that it is to be used the immediate 3 weeks after a qualifying event. And a qualifying event is obviously giving birth. So if, for example, it's good. One of the issues you're going to address is if the qualifying event, the birth of the child, takes place during either the summer or during winter break or spring break, that let's say it's spring break, that week of spring break, they don't get to count that as one of the 3 weeks of maternal birth leave, meaning they now, when they come back, they get 2 weeks of maternal birth leave, not 3.
So it's the 3 weeks immediately preceding, immediately after the birth.
Correct. So if this happens during the summertime, there may be a situation where the mother would not be entitled to use any of the maternal birth leave. One of the things that you need to be aware of is that if you don't use maternal birth leave, you do not have the opportunity to be paid for it. So the only way you can do that is to have the qualifying event occur during school time, right, and not on a holiday. So it could be very interesting to see if we have a shift in when our employees have their children.
The big thing with this, update your policies. A lot of people freak out about not getting them updated by July 1. You're supposed to have them updated by July 1. However, a lot of times the bills don't get signed until it's so late, unless you did an emergency process with your board. You don't have a time to have the normal first month reading, second month passage. It's not the end of the world. Just get them passed and make sure you follow them. The big thing is making sure you honor whatever the new law says, even if your policy has not been approved by the board, maybe a week or two down the road. Don't stress about it. Get it done as quickly as you can and follow the new protocol.
The other thing I want to mention, very similar to our situation with the 5 personal days, make sure that you include this new leave in your actual policy and then in your handbook, your employee handbook, or any information you give to your employees. Remember, they have to qualify for this leave, they have to have worked with you, your district, for the 6 months prior to, or if they're hourly, 700 hours prior to. It's not just automatically
6 months or 700 hours.
It's something
not a new employee.
No, yeah, and you have to keep up with that. So that's one of the things that you'll have to pay attention to. Now, I have had situations with paid parental leave, etc., where we have situations where an employee is just shy of the required time before they can have this. If we're talking a week or two, quite candidly, this is going to be up to y'all as to whether you allow them to qualify for the leave or not. I can see it both ways. My only concern is this. If they're a week shy and you allow them to go ahead and qualify for maternal birth leave, then just get ready, because then if it's a week and 3 days, it just worries me. I would tend to do it this way. You either qualify for it or you don't. And then you move forward.
Makes it easy.
But that is something that you can do on your own.
All right. I don't think there's a lot of conversations that we need to have on this, but the cell phone bill went through that's enacted as of 27-28 school year or sooner. I know up in our area, most everybody rolled that. A lot of my districts rolled that 9-12 anyway last year. Anything you want to add on the cell phone bill? Cell phone ban, rather.
I do. I want to make sure everybody understands it's not just cell phones. It's personal electronic devices. And what we're seeing is a couple of things. For example, we had one issue last week or something dealing with a GPS type communication device. That's something of that nature. That is actually one of the devices that would be considered a personal electronic device, because it can collect data and you can communicate back and forth with it. So that could be a situation where you would want to prohibit the student from having that, or work with the parents to address how you're going to deal with that. If you have those type of devices, or a Dexcom, the device for insulin, I think it's Dexcom.
I know what you're talking about.
You're going to address it through a 504 process and allow these students to have these things. The other thing that I really want you to think about, and the bill itself allows you to do this, is when you have students who are in dual enrollment, dual achievement, doing some type of work-based learning.
They're coming and going from campus, basically.
You can set up and have different rules for those students. My little girls did work-based learning and dual enrollment. And technically, if this was in effect when they were in school, they would not be allowed to use a cell phone when they leave my house going to UNG, or when they leave my house and go to the hospital. And that could have been a problem several times, because the hospital would call my girls and tell them, oh, don't come to the emergency department, go to this because they have some issue. If they can't use their phone during that period of time, that could be something that would be an issue. So you have the ability under the bill to come up with various rules or guidelines for those certain circumstances. That's where I will just tell you, as a parent and then as a lawyer, that's where I can see the main issue arising, is when they're leaving to go to an apprenticeship and the individual can't get a hold of the student before they get there.
I think this is just where we got to be practical, and we got to make some common sense decisions in your policies. Like you said, you have the flexibility to handle that differently for those students. So you make the policy reflect what works for you and what makes sense. You want your employers to be able to contact the students, and they need to, especially when they're off campus. So I don't think that's going to be a big problem, and a lot of districts are working that out as it is already.
The other thing that we're seeing is a lot of districts are trying to figure out how they're going to address the phones in high school, and whether they need to address how the students deal with their phones. For example, you can have the pouches in elementary school, but in high school, you don't necessarily have to have the same way of method of addressing the phones in each level of school. So in high school, you can just simply tell them to put it in their backpack and not get it out and address it that way. But it is something that you need to be aware of. You also need to let the parents know as soon as you can that this is what we're doing. High school students are now also going to be included. Those districts, and I don't know if you've heard this, but those districts who have already included high school students in this ban, they're not getting that
It's not been a
much.
problem. It's been very positive for the most part. It's been a good thing. So. All right. The next one, I don't know how much conversation we might want to have on this one. Considering whether findings of fact are required by local boards or tribunals in some student discipline. You want to hit on this and what
Gee, Tim, I would love to. Thank you.
This may be a whole webinar in itself.
And quite candidly, I do think that if this is something that folks are interested in, I do think it could wind up being a completely separate webinar. There has been a case out of the Court of Appeals in the state of Georgia where the Court of Appeals, in my opinion, I don't think it's a very good decision, but has suggested that boards of education, when they are serving in their appellate role for student discipline situations, have suggested, not only suggested, but said that boards of education need to create finding of facts. That is a process where the board would say, this fact, here is the facts as we understand them and believe them, and write it out in their decision as to whether to uphold or change the tribunal's decision. I do not believe that's what the law says. In fact, the law says we're supposed to base these tribunals on the any evidence rule. Is there any evidence in the tribunal and in the tribunal process that we can say supports the tribunal's decision, and thereby that's what the board is supposed to make its decision on? It doesn't have to go through a finding of fact. My concern, and I think our office's concern, is that this is going to open up the boards of education to more appeals to the state board, because now lawyers have more targets to shoot at as opposed to the any evidence rule. So I'm concerned that it's going to take more time, more money, and more effort to address these appeals by boards of education, and thereby make the discipline process as we currently do it with suspension and expulsion that much more difficult. So we'll be dealing with this in the future, and I'm happy to work on another webinar if you'd like to do that. Sure.
So really, as far as you're concerned, when he's talking about the appellate situation, that's where your board is hearing an appeal from the tribunal. So the parents went to tribunal, they don't like the renderings, so they appeal to the local board. The finding of fact falls on the board based off this law. Really, for boards and for people on there, just do what you're doing and make sure. I mean, you should have evidence and you should have facts to begin with, or you wouldn't have kicked the kid out, or you wouldn't have held up to your ruling. So sounds like it's going to be more of an issue moving past that board.
Yes.
Jury's kind of still out on that. We'll see what happens. And so probably not a lot you need to be doing. If you're doing your tribunals right, probably not a lot you need to change on that. Safe to say?
Yes.
All right, next one. Next one's kind of interesting too. We have the True Patriotism Act and Universal Student Access Act. So this may cause you to make some changes to your handbook as it deals with student clubs, meetings, dress that seeks to engage in politics. So talk to us a little bit about the True Patriotism and Universal Student Access Act.
The part that Tim's talking about in the bill itself, it addresses quite a bit of things. But one of the things it says is that students are allowed to wear clothes, have accessories that have various politically charged symbols, words, etc., to the same extent that all students can wear them. So what it winds up addressing are things where students may want to wear a MAGA hat. And typically, if we allow any student to wear a hat that has words on it or symbols on it, then under this statute, we can't prohibit students who have politically charged or political messages or symbols on the hat. So let me give you some examples, because I think that's very helpful. If you all allow students to wear University of Georgia hats, then other students could wear MAGA hats. They could wear Let's Go Brandon hats. They could wear
Really
Democrat. anything that has political messaging or situation, they could wear that. In fact, they could decide, hey, let's have Cochran for sheriff on it.
Pretty good.
That would suck.
That would be pretty good.
That would
or for
suck.
governor. Why just sheriff? Governor. That's another webinar.
That I will not be on that webinar. But those are the kind of things that you can see. So my concern is we're going to have more and more of these situations where we have students wearing either local political oriented shirts or accessories. We're going to have them wear state, and certainly going to have them wear national things. And that could be a problem. Now, all we're talking about there is candidates. But think about political activism and these kind of things. We could have Black Lives Matter hats or t-shirts. We could have things that talk about defund the police or something about ICE. All of these things could come into our system now and into our district. So you have to decide how you're going to address this. One way that I see is you could just ban all of that. Nobody can have any shirts or clothing that has any messages or symbols. But when you do that, you got to start thinking about that, because now you're you're almost like a uniform then, because the number of shirts that you have that have symbols on them, the Nike swoosh, Adidas, things like that, all of those you couldn't have. Hats, you couldn't have those. Shoot, even Carhartt t-shirts have the little C over there. None of if you allow those, you would allow all of these other things. So you have to think down the road. One, whether or not you want to allow the political messaging, etc. And then two, how that's going to affect those students who aren't going to even be interested in wearing those. It's not going to be an easy fix. Either way you go, you're going to have folks fussing about it. Either when you say nobody can have any symbols or messaging on their shirts, or if you allow the symbols and messaging, then you're going to have parents and others upset that somebody's wearing a raised right Republican t-shirt, and that shouldn't be allowed in school.
And you correct me if I'm wrong. I don't see it as being very dramatically different than our dress codes now. If you put the language, I would put the language no symboling that disrupts the school day.
And I think you can
I think that's
include
pretty
that.
simple.
Now, I don't want you to think that there's still some, and even when you were superintendent, Tim, there are some symbols, there are some messages that I don't care whether we ban them or not, you can't have them in there. This does not affect students wearing Confederate flags.
Yeah,
that's still, you can still address that. This doesn't change that. And just because you allow kids to wear Nike or University of Georgia doesn't mean you have to allow them to wear, as Tim said, swastika or the Confederate flag.
I don't see a huge issue with this. Like I said, your language about, anything we always do, if it's disruptive to the school day, then you can address. You're going to have some issues from here or there with kids pushing the line. The big thing to make sure you're aware of is the meeting side, because you're an open public forum. If you allow groups to meet, you already are. Cory's talked about just having a football team. Some judges think that makes you an open public forum for some things. So understanding that and having a student wanting to start a number of clubs that could potentially be controversial in some areas of the state, make sure you understand your policies and protocols, because you can't just say no to one group and allow another group that you agree with. You want to touch on that in any fashion? I think that's going to be the biggest issue that might hit some people.
When Tim referred to a limited open public forum, one of the things that you have to know what that means. And I think I can boil it down to, if you have non-curriculum related clubs
FCA
that meet on your
FCCI.
campus, that uses your facilities, that makes it a open forum. And as Tim said, the one that I tend to use as an example is FCA. if you have FCA, you are now a limited open public forum. And there, because of that, then you cannot prohibit a student from starting Young Republicans, Young Democrats, Young Libertarians,
Any number of
any of them. They still have to be completely student-led. They still have to be complete student-oriented, etc. You can still have the current process that you have now for a club to be created. Students have to come up, students have to have a sponsor, and if they do it during the middle of the year, you wait until next year. All of that's fine. What you can't say is, no, you can't use our facilities because we have a limited open forum. Now, in the bill itself, there are some really unusual conflicts drafted into the bill itself. It first says things such as no employees can be sponsors of the club. And then it says no one outside of the club or outside of the school district can come routinely. So I'm not sure how we do this. Interestingly enough, later on in the bill, it does say that school districts and employees of the school district can serve as in custodial roles with these organizations. As they refer to it, that custodial role, that individual, that employee is there to make sure that the students at these clubs and at these meetings comply with the code of conduct. That's all that individual is to do. That individual doesn't participate. That individual doesn't discuss. That individual doesn't lead. That sponsor, that individual is there solely to make sure that
custodian.
Yes.
Not that sponsor, that's custodian.
That Tim doesn't pull out a vape and start vaping in during the meeting. So I think that's important for you all to be aware.
The big thing is if you have a request, you have a challenge, make sure you get with Cory or your local attorney and make sure you're on par with the new law, because there are some caveats to this new rule. While we're on that note, let's talk a little bit about the Patriotic Society, about being, wanting to come speak to the kids during the school day. There was some language around that in this legislation.
This was an interesting aspect of the bill. It allows patriotic societies, and they're defined in the statute as those societies listed in Title 36 of our federal statute. There is a long laundry list of patriotic societies. It obviously includes Boys and Girls Club, the Scouts, but then it has a long laundry list of other entities, the VFW, other groups that could come, American Red Cross. It authorizes them to send to the superintendent a letter at least 30 days prior to the date that they want to come and talk to students about civics and that sort of thing. Now, the superintendent has the ability to respond and say, no, you can't come that day, but you can come on this particular day at this particular time. If you're going to respond, you have to let them know when they can come. So it has to do with things, and it makes sense to me, Tim, if you have testing going on, if you have other things that these individuals coming to school during that particular day of that month would be a problem, you can reschedule it. It doesn't provide, at least the way I read the statute, where you can say, no, you can't, that patriotic society, you can't come to our school.
Let's talk about, does this mean we have to give them an agenda at a forum like in the gym, or they can just set up a table during lunch to speak to kids as they choose to speak to them?
Yes, you can do either way.
If you don't have to provide a forum like a big assembly, you don't have to do that. You can set up a table in cafeteria and let the kids go by if they choose to. We've done that with organizations through the years. I'm sure you guys have too. So I just want to make sure we're clear on that.
I think though that the idea was, quite candidly, that we would provide some type of convocation type situation, but it's not how the bill is written that would require us to do that.
Right.
So It's an interesting bill. I don't know how much we're going to have of that type of issue.
It's going to be very probably small in some of your communities. You got some, I guess, lack of better words, some radical groups in some of your communities that are going to stay on top of this, to use this as a way to come into your schools. Just be mindful. You can't say no until you check it out. You probably need to provide some sort of forum.
I could see various groups coming that are on the list coming during Veterans Day, or something of that, which I think is great.
It's probably not the ones we're already working with that we have good relationship with that's going to catch you. That's the trick, and y'all know how that goes. It's that group that wants to stick their head up just so they can cause some trouble because there's a mom and her daddy that's disgruntled because you had to suspend their kid or kick them out of school. That's going to be the ones that catch you. So just be aware of it. Reach out again to Cory, your attorney. It pops up.
Or Tim. Just reach out to
Not
Tim.
legal counsel. I do not provide legal advice.
It doesn't say that on your...
It doesn't say legal expert on here. But I'll tell you what I would have done as superintendent. But again, Cory doesn't condone most of those actions either. So,
amen.
All right, ID badges. If you do ID badges in your districts, if you provide kids an ID to wear, so a lot of people do that. They have the strategics or the emergency panics, and you have an ID on front of that or whatever. If you provide an ID badge, you have a new regulation starting effectively now, correct?
Yes.
Starting 2 weeks ago, whenever your kids came to school. So you want to talk to them about that?
It requires school districts to have specific language on there about 988, you are not alone. Actually, interesting. I was watching the news yesterday evening, and a commercial came up about 988. It is a suicide hotline. It's a national suicide hotline. There is specific language in the statute, so if you need that, if you let me know, if you let Tim know, we can send you a copy of that statute. If you've already printed your badges, but you did not put that on there, I think what you can do is print stickers and stick them on there. Just so you know, I was curious as to who was on the other end of that phone on that number, so I called it. I just wanted to be able to say who's on the other end of that phone, and it is the National Suicide Hotline. Did you have a long conversation, or was it a short conversation? No, it was very short.
Very short.
I explained to them what I was doing and why I was doing that. They directed me to their website.
I thought it was because he had to be on the webinar today.
Maybe. Well, with you, yes. But nevertheless, I just think it's important that you all also know who's on the other end of that, because I can imagine there are going to be some parents who are going to say, I don't want my child having that. I don't know who's on the other end of that phone. At least now you have an idea of who's on the other end.
So if you haven't gotten that, you needed it 2 weeks ago. So something that was passed and effective at the start of this school year. Another thing that's coming up in January, it's effective as of January of this upcoming year, January 1, school safety plan must include a behavioral health needs of students and a behavioral threat assessment management plans that are approved by Department of Health. GEMA is supposed to provide assistance with this. I know in Pioneer RESA, we have GEMA coming October 5th to do a training for our districts that need it. It's a 6-hour course. Anything you need to add on that?
That's from one of the statutes from last year that has lapped over. I like the idea. I think it's very helpful, but I'm glad Tim brought that up because it was from one of those that lapped over from last year. And I'm sure if you all need some assistance with having somebody come down and provide this training, you can reach out to Tim and he can get you in touch with GEMA.
And your local RESA director as well. GEMA is phenomenal. Do a lot of these services. They'll come do walkthroughs in your districts for a lot of different things. So do not hesitate to reach out to your local RESA director and GEMA. They'll have access to that because they do a lot of services. They have a lot of quality services to help you guys that need it. Again, if you have questions, don't hesitate to reach out to me. But your local RESA director also has access to that as well. So anything else you need to add on that?
No, I think
again,
covers it.
One of those laws that's held over. We talked a little bit about personnel leave and stuff, but we got some new enrollment procedures concerning foster children. You want to touch on that?
Last year it was House Bill 268. We had a massive redo of enrollment and the process that we're going to have to use. It involves now RESA as a component of this. They couldn't leave well enough alone.
No.
So they had to add something else, and it's specifically about foster children. And this new provision says that you all have to enroll foster children immediately, but in no sense and in no circumstances less than 3 days. Now, it doesn't say you have to enroll them permanently, temporarily. So the way I look at
Virtually.
if you don't have the critical records that was required last year by the bill, then what I think you can do is enroll them temporarily, either in person or virtual, and then you can go from there. Now, what's interesting, and the question that I seem to have starting to have to address, is what happens when you have a school district who says, nope, we're not going to enroll them. I don't think any school district.
We've never been able to do that.
No, but that's what we're getting questions over. I don't think any school district saying, no, we're not going to enroll the child. What I do think school districts have a problem with is, where do we place the child? Are they supposed to move from 3rd to 4th grade? Or should they be in algebra or geometry? And you're not going to know that until you get those critical records. So the question we get a lot of times from DFACs, et cetera, is how are school districts going to address that? And quite candidly, if we're dealing with it from the standpoint of we don't have the critical records, their class schedule, their classes they've taken, IEPs, enrollment, all of that stuff, candidly, I think we would have to use the process that has been in place last year, where we have the RESA student affairs officer try to reach out to the parent. In this case, the parent is going to be the state of Georgia, DFACs. And the problem I see is we're going to have one political subdivision of the state of Georgia being a school district, and RESA is not necessarily a political subdivision, but reaching out to a state agency saying, hey, we need these records to enroll this child. And that's the same freaking agency that is coming around trying to make sure that we're enrolling the kids immediately or within 3 days. So that's going to be a bit of a, well, Phil refers to it as a sticky wicket.
Sticky wicket.
Which I'm not sure what that is. That's going to be the concern that I have.
At the end of the day, we have to take kids. We have to take them. We always have. But you've got freedom and some flexibility about where they're being enrolled. And so, although that may not be the easiest thing, or maybe a headache, there's nothing that says you can't virtually enroll them until you get all the information you need. Now, you may not know what to virtually enroll them, but you know what? Do the best you can. There's some things you just can't. There's so much that goes on in schools. Some things you just can't stress about. And, try to find things that are as easy as possible to deal with, so that you can save your energy, focus on some of the things that you're going to need to focus on. Because at the end of the day, you can't tell a kid no. You do need records. You do need to know some of the critical things. But you've got the flexibility. Just don't say no, we're not enrolling you. Then you're not painting yourself in a corner.
I think the interesting thing that I would want to know from you, Tim, is as a former superintendent, how often did you actually have a foster child come in without some record or some idea of where that child needed to be placed?
Yeah, you're going to have some cases here and there, and there's some areas of the state that have some more. I know Metro has had a ton of issues with having to refer records requests to the RESA, because we just got so many more kids, so many people moving around. They got a lot of private schools not releasing records because of tuition that's due. That's not really the foster. I've never really had a huge issue, but y'all know how these laws get created. One person fussed to the right legislator and they passed the bill to fix it. So who's to say it was a widespread problem? With what's going on in our state the last couple of years, with some of the tragedies that's occurred, it has ramped up the attention around critical records, making sure you've got everything, and then schools are trying to make sure they're safe. And then maybe pushing, some kids, not pushing them aside, but prolonging bringing them in until they get all of that. Again, you've got flexibility of where you enroll them. So use it to your advantage until you get the things you need. One of the foster kids we've never had a huge issue with. Those are kids we're trying to I don't know.
One of the things that I would want y'all to make sure of is that you let your registrars know,
Right.
and candidly, it's not necessarily going to be your school administrators who initially deal with this. It's going to
It's gonna
be
the registrars
the person who's at the front desk
or on the phone.
when this child is being brought in
That's right.
as a student. I just want folks to be able to understand that if in fact these students are foster students, foster children, we can't necessarily treat them the same way we would any other child. We
True.
need to be a little more, there has to be a little more urgency with these, and we try to reach out and explain to the parents and explain that we need the records sooner rather than later.
All right. Let's talk about after school. Any 5-6 school operating a pre-K must offer any after-school program that the school offers to the pre-K student as well. So if you're in a pre-K, if you have pre-K and you have after school for the 3rd, 4th, and 5th graders, got to offer it to the pre-K students now.
In the same manner that you do the pre-K. So for example, and this is where I think it's coming from, but I can't necessarily guarantee this. Some school districts have after school care, but they have it just for the employees' children. Now look, I'm not fussing about it. I know that would have been a huge selling point for my family if they had that, and I get why schools want to do that. Now, I don't think you can do that, because if you have pre-K program, whatever you do for that pre-K program, you have to do in the same manner for the after-school program.
Let's talk about if you have a 21st century grant, and that grant lays out which students you're serving, but it doesn't include pre-K. Now, the grant pays for those kids, but now that the grant won't pay for pre-K,
you've got a problem.
You've got to add pre-K on your local dime to in the same manner that you're providing for 21st century.
And I do think that our 21st century grants next year will be aware of this. I don't think it's going to be a situation where we have to do this each and every year, but for this year, you're going to have to be aware of it. It does include 21st century grants, or at least we certainly believe it does.
And that's effective as of the start of the school.
Correct.
So that is in effect. All right, moving right along. I think we're making decent time. We will not get to every law today, guys. I hope y'all know that, but we're just trying to hit some of the high points. As of October of this year, you're going to have to turn in October 15th. Actually, you'll have to turn in a report.
27.
Oh, excuse me, of 27.
You meant school year.
Yeah. October. Lord have mercy.
I know.
Geez. Anyway, you've got a new regulation coming up about considering the cost of repairs, expected life, and salvage value of new technology when you're making purchases. And also, you've got to submit a break fix rate to the State Board of Education. I don't know if that's going to be a huge issue. I know our guys in Bainbridge, when I was superintendent, I mean, they had access to all of that. They kept records. We had, inventories. Probably was something that was readily available to be able to be pulled, but that you need to be aware that's coming down the pipe for 27, that you'll have to submit those reports. And I'll be honest, when I put this on here, I saw 10/27, and I'm thinking it's coming up October 27th, not October of 2027, but this is actually coming up at 2027.
One of the things that I want folks to realize is that there is a dollar figure limit. It's not just computers. It's a dollar figure limit for electronics. And I'm just going to tell you, most, if not all, of the electronics that a school district purchases are going to be above this dollar limit. So even those scientific calculators, I mean, the limit's like $100. So some of those scientific calculators are more than that. Not only do you have calculators and computers, but tablets,
everything.
What are those boards? Those
smart
boards, projectors. All of that is going to be included in this. Now, as Tim said, most of your IT folks are already doing something like this. I tend to look at the why more than the how now. And I'm trying to figure out why our legislature wants to know all of this information. And to me, it only seems like what they're trying to do is figure out well, maybe then we can try to figure out which one is the most cost effective computer or tablet, and then get into the weeds as to what school districts can purchase based on this information. I don't know that to be true, but it just seems odd that they would want to know all of this information and then not do anything with it.
Yeah. All right, so that's down the pipe. Now we're about to get into some financial stuff. And some of this is pretty deep, and some of it is probably going to be more for district office folks and maybe even boards, but we'll talk a little bit because it impacts your community. So first thing, Senate Bill 33. Senate Bill 33 is a new tax bill, especially is going to impact any of you communities that opted out of House Bill 581 a couple of years ago. Where do we start with this one?
Let me see. As Tim said, House Bill 581 was the bill in 2024 that allowed boards of education to either to opt out and not be subject to what they call a floating homestead exemption. A floating homestead,
which is basically a cap on your appraisals on homesteaded property, how much it can increase in any given year. So it's basically a cap on the values of homesteaded properties.
And typically what's happening, now you tell me if I'm wrong, but what's happening is the cap is based on CPI.
Consumer Price Index.
So if the Consumer Price Index goes up to 5%, then school districts, cities, and counties can
the value of
actualize.
Your value of your home cannot appreciate more than this consumer price.
That's
index.
right.
So with a lot of people's rising values, with everything's gone on in the last 5 to 10 years, your $100,000 home that's now worth $400,000, you couldn't increase that much under the consumer price index, basically. So it's capping that value.
It doesn't affect the mill limitation of a school district. You still have 20 mills. Now, there are some of you who have a local constitutional amendment that allows your millage rate to be beyond 20 mills.
That's very few, though.
Very few. But for the majority of you, that 20 mills has not changed. What has changed is, in essence, the value of those mills, because you're not going to be able to actualize the entire increase of the appraisal. It's just up to the percent.
So what has still been Senate Bill 33 do? It basically opted everybody in that opted out of 581 2 years ago. So those of you that did not have a cap on the homestead properties now has a cap. The thing that I want to mention here to you, we won't get into the weeds on this. There's a couple things you need to know about this bill. One, the way we interpret the bill, it's going to recalculate a base year. So at what year does this cap start applying?
Yep.
Based off our understanding, the law says in 2024.
That's right.
We're in tax year 2026 right now. So there's been information that's come out from the Municipalities Association, your City and County Government Association, basically saying start this in 26 with a cap of 25. Well, that's not our interpretation of the law. It's pretty clear it says 2024. But what you need to know is you need to have conversations with your local tax people. You need to figure out when this bill is going into effect and when the base year goes in effect. Because if the base year is 24 or the base year is 25, it's irrelevant when it is, as much as what happened to your digest that year.
Mm-hmm.
Because if the base year is, say it's going to be 25, which was last year, and you have a digest coming out this year in 26, say your digest went up $100 million, you're collecting taxes on an additional $100 million that's going to go back if the base year sets to 25 or 26. So the base year, where it sets, is a little irrelevant for you as much as it is. You need to know what happened during that year, because if you roll your millage back a lot because you had a bunch of growth and then they set your tax back, you need to understand you're going to lose some value in that millage. So you might have rolled your millage back and turn right around and maybe have to roll it back up the next year. So for those of y'all that opted out of 581, it's not going to be an impact for you. For those of y'all, for those of y'all that are already in 581, it's not going to be big for you. For those of y'all that opted out, you need to talk to your tax people, figure out when they're rolling it, when your base year is, and then start digging in. Your CFO is probably very well aware of what's going on here. A couple of things within the bill. There was also language in the bill when the state adds these exemptions. There was language initially in 581 that they exempted these homestead properties of this cap, but this exemption was not going to be counted off a local fair share. So it kind of counted against you. In this language, in this new bill, there is language, we think, that means they're not going to credit this against your local fair share, which is a good thing. But understand there's a 2-year lag on local fair share. So a lot of superintendents in our area were thinking, okay, I didn't get my local fair share bump this year. Yes, because this hasn't gone into effect yet, and it's a 2-year lag. So even if you get a bump in local fair share, and some of y'all will and some of you won't based off what your digest does, if your digest went up a bunch, then it may impact you. You just need to look, because every one of you, 180 districts, going to have 180 different scenarios. So you need to look into that.
There's an ironic twist in this bill. When in 2024, all the legislators were very a big proponent of House Bill 581, mainly because, as they said and as they believe, school districts had too much money in their reserve. I found it ironic, considering that after you did some calculations, you found out that the average reserve for a school district was what?
Around 3.7, and the state was at 4.7. Excuse me, the average difference was around 3.7 months in reserve. The state was around 4.7 that year, and the state charter schools were at 5 months.
So that was the thing. We just had too much money. Well, in this bill, the legislature actually increased the percentage that we could have of reserve from 15% up to 25%. Now, to me, that signals something that's somewhat concerning. Our legislature, virtually the same entity that said we have too much money, is now suggesting you might want to have more.
It's a mess. So if you have questions, don't hesitate to reach out to either one of us or your RESA directors, and we can get you more information on Senate Bill 33 as it impacts you locally. We're trying to wrap this up in an hour. We may go a tad bit over because we want to hit our topics and take a few questions if we can. We only got 3 more things we're going to talk about real quickly, and then we'll take questions. So real quickly, literacy coaches, big bill that got passed this year. The literacy coaches were supposed to have been hired by August 1st. There was a lot of misinformation out there about what was going to happen if you had not hired literacy coaches. Now we're being told that you're not going to get served if you didn't hire a coach. I will tell you, all of your RESA directors have pushed back on that, and the legislators have allowed us the flexibility to serve all our districts. It will look differently this year if you didn't hire a literacy coach as compared to those of you that did hire a literacy coach. We are being told moving into next year there will be more restrictions, and there'll be a new program yet again for next year that's coming out of Georgia Southern. That was all in the bill. Here's my thing with literacy coaches. Mainly with the literacy bill, you got till January 1 to roll out your literacy, your district plans, your literacy plans. Your local coaches, your local RESAs will be working with you, helping you. You should have already gotten information from GOSA on that, or GOES now, and your RESAs. There's a lot that can be discussed on this. The big thing I encourage you is talk to your RESAs if you have questions. More importantly, talk to your legislators. Make sure they understand how your coaches have been serving you. Make sure they understand the services you've been getting for the last year and a half. And I say year and a half because the RESAs just rolled out the coaching program 2 years ago, and last year was the first year we got enough coaches to really hit all of our districts. I know in Pioneer RESA we had 2 positions the first year, and I got 14 districts. Not realistic to serve 70,000 students with 2 coaches. Now I'm up to 9, and 9 is still a challenge, but we can hit all our districts. And so, but it's really important. A lot of you guys on this call, if you're not in the superintendent's chair, you're probably not very active in talking to your legislators, but I'm telling you, it makes a difference. They don't hear all the information. They hear one story and then they go write a bill trying to fix that negative story they heard. Sometimes it's very reactive under the gold dome instead of being proactive, but your story makes a difference. So let your people know. talk to your RESA directors if you have questions, talk to your RESA directors if you have problems, and let the legislators know what's going on with your coaches. I know in Pioneer RESA, it's gone really well, everything I can tell, and the coaches we have are doing a great job. I hope we can keep that flexibility moving forward. We had a little flexibility this year, but we're being told that's going to change next year already. So the jury's still out on that. I'm not going to spend a lot more time talking about it. Anything you want to add to literacy?
No, I think we probably need to move on to the finance bill. This bill is a result of very specific issues, and I'm sure everybody understands that. One of the main thing I want you all to understand about this new bill is the Department of Audits now has a bigger stick. And we go from 5 different tiers of financial, I guess, readiness we refer to 4. Only one of those tiers is the tier that you all want to be in. Nobody wants to be in tiers 2 through 4, because if you're in tiers 2 through 4, you're considered at some level of risk and have a whole laundry list of onerous tasks that you have to do.
And let me clear up before he goes to, but this bill he's talking about is the new bill based off your financial audit.
That's right.
And the security of your finances in your district. And it's came strictly due to some situations that went on in another county that everybody's probably very aware of, but it has some very serious teeth, and a lot of regulations with that. So that's the bill he's referring to.
The problem now is that when you have audit findings now, it can move you from one tier to the other relatively quickly. It doesn't even have to be a major finding. Whereas last year, if you got an audit finding or something, it was kind of a slap on the wrist, you moved on. That's not necessarily the case now. So I am concerned as to how the Department of Audit is going to treat this, whether or not they're just going to move us from one tier to another based on something that is as I would refer to it as just an accounting finding, as opposed to a misappropriation of funds type of finding. The long and the short of this is right now we're building a plane as we're flying it.
And when he says we, he's referring to the Department of Audits.
Yes, we're not.
Department of Audits.
And I think we're going to have to give them a year right now to try to figure out where that's going to go.
Couple of things on this. I know a lot of people on this call, you may not be the in the finance department or the superintendent, but all of you do POs, requisitions to purchase things, and then there's protocols in your district that have always frustrated you probably in the past, because you're like, why do I have to do this? I've done this. It's only going to get worse. And let me tell you, that's cause of the directions coming straight from the auditors. These things have a lot, like you said, a lot more consequences now. The reports, you have to have report certifications of audit readiness, that there are no delinquencies in any sums to TRS, to PSERS, to State Health, Department of Labor. That's got to be signed by the board, the superintendent, and the CFO, the board chair rather. Board members can be removed from office if you fall too high the risk factor, and the risk factor is all coming out of the Department of Audits. So we can't tell you right now what gets you in that. That's the fear thing. Also, if you are in the higher risk categories, superintendent can have no more than 1 year on their contract, starting effectively now, right? July 1 of this year. That creates everybody can say, well, if the finances aren't good, superintendent shouldn't get extended. I know from experience, sometimes it takes a couple of years to get a district off of a risk, high risk, or even low to moderate risk. It may take you 2 to 3 years sometimes to come off of that list because of how things proceed and work in a district. So, and then who wants to jump in on that as a superintendent? I say all of that. Just know that's going to impact your procedures. Your CFOs, your finance departments will take guidance from the auditors. I'll also like to say this. An auditor can recommend a lot of things, but a recommendation and a requirement are two different things. And I don't want to say the wrong thing here, but be careful with recommendations, because auditors always have a lot of recommendations. That does not necessarily mean the same thing as a requirement. So Finance departments make sure you and your superintendent are in agreement. Y'all understand what the difference is between a recommendation or a requirement. Because if you start taking every requirement that you get from an audit department, it can be pretty cumbersome. I mean, I'm pretty safe in saying that.
Well, we've come to our full hour. Gavin, are there any questions in the chat that
definitely can't hit all of them, but if we have a couple we want to hit on?
Yeah, sure. So I could read some of them off. Going back to the bill we started with, talking about maternity leave, paid parental leave, those kind of topics. Two questions sort of in that vein. One question is, do we need to accept unused paid parental leave days from another system if someone transfers from another school system and did not use all 30 of those days in that system? Or does the 6-month eligibility rule apply in this case as well?
Good question.
The way I interpret that is, in order for someone to be eligible for paid parental leave, they have to work with your district for the required period of time, not in a public school district in the state of Georgia. So given my interpretation, I would argue you do not have to accept you do not have to transfer unused paid parental leave from one district to another.
And then they said
that's the way I would understand it and try to interpret it. Yes.
So the other question was, so these days are not to count against their sick leave bank. I don't know if that question was for the maternity leave or paid parental leave, but
okay. My assumption is they're asking about paid maternal leave.
Right.
And the answer to that is that's correct. Well, this is a separate and distinct leave that our employees get if they qualify for it and they have the qualifying event. So that would be 3 weeks in addition to any other leave that the employee may be entitled to. Now remember, you can have FMLA and FMLA leave and paid maternal leave run concurrently. Right. So that it avoids the stacking.
Other questions?
On the topic of when we were talking about finding of fact and the appellate and that topic, there's 2 or 3 questions I'll read together. So one is, as it relates to requirements for findings of fact for school boards, do you read this only for student discipline or also for appeals to the state related to teacher termination hearings? In other words, if we have a teacher termination appeal from the district to be reviewed by the state, should we expect the matter to be remanded to the district for findings of fact?
That's an excellent question. Right now, the Court of Appeals decision was based solely on student discipline. So that's where I'm holding it tight, is to student discipline. I would not be surprised if it gets to the Court of Appeals, if they don't expand it, not only from student discipline, but to teacher terminations. I don't understand the Court of Appeals and their decisions sometime, and that's one of them I just do not understand.
Next
Same
question.
vein, are juvenile judges or courts required to inform Georgia school districts when an off-campus incident resulting in an alternative school placement has been adjudicated?
We're supposed to know that. That's been in statute
forever,
for years.
But there's no teeth on it, they don't. And there's nothing we can do other than you can refer them to your RESA.
That's part of the critical records we were talking about when you have a student enroll in your district. One of the things we're supposed to be made aware of is whether the student has committed a Class A or Class B felony and have been adjudicated for it.
And that's never changed. That's been in there a long time. But it does, again, there's no teeth if they don't let us know.
On the topic of devices, have you had any dealings with smart glasses for students being an issue if they're prescription and needed for the work?
Actually, yes. Those, if you're referring to those Meta glasses, then yes, those are personal electronic devices. But remember, if there is something there that the student needs to continue their education, we could address it through a 504 situation and through a plan. But if the meta glasses are also prescription glasses, they can have prescription glasses that are not meta glasses. So you would just have to have the good old Tim's old man glasses.
Absolutely.
You would just have to have those type of glasses instead of prescription glasses that are also meta glasses as well. But we are seeing some. In fact, candidly, the last one I had was a teacher who had prescription glasses that were meta glasses. So we had to kind of work a little bit out with that.
On the topic of pre-K, does the pre-K after-school requirement include after-school tutoring programs paid with Title I funds?
Really?
That is an interesting question.
Tutoring is not, well.
I would tend to, off the cuff right now, argue that is not an after-school program.
Yeah, I would say, because tutoring wouldn't necessarily be open for all students anyway, maybe. You probably want to try to justify that as not being an after-school program unless you were pushed on it.
The statute is not clear about that particular issue, though. How about a couple more questions, Gavin? And then
let's take two more. And before everybody starts jumping off, Gavin will go back through this. Please put in the chat and send him a message if this has been beneficial, if this is something you like, something you want to see more of.
If you want to see less of Tim, for God's sakes, please put that in there too.
Or less of Cory, because I mean, that goes both ways. This is something, we're willing to do a little more often. We do want to apologize in advance for having to move the date.
Yes.
Cory is very inconsiderate of y'all's time, and he made us change the date. Of all things, he had to go to a funeral.
I do apologize. That was my fault. We had a family funeral and I had to take my mother. She doesn't drive anymore. So I apologize to everyone, and I do appreciate your all's willingness to reschedule. But let's try those last
two questions, and make sure you leave any comments you can for Gavin as we move forward and figure out if we want to do this more often. Two more questions, Gavin, we'll wrap it up.
Okay, so I've got one more question, and everything else is just super positive feedback, 2 or 3 different topic requests for the future, so I can get that to you guys. The
positive feedback was about me, though.
No, absolutely not.
Go ahead, Gavin. I'm sorry.
They a couple of people said they enjoyed the pre-show. I will throw that out there. You guys getting set up. So question: if a school district's audit or last was moderate risk, even though the expanded list of designations was not in place, does the new reporting requirements apply to last year's audit, or would they go into effect with the FY25 audit findings under the new designations?
That's an excellent question. I'm going to tell you right now, I don't honestly know, and I'm not sure the Department of Audits knows, but the problem is I don't think last year's audit is going to be the issue. I think this new audit coming up is going to be the issue.
The law said they had to, correct me if I'm wrong, the Department of Audits had to start this year developing a plan.
That's right.
To be completed by the 28-29 school year.
That's right.
So we don't know. But I will tell you, for those that are not in your audit, we are already seeing at Pioneer RESA things that have never been looked at the level they're being looked at. So no matter what, you're already going to feel it in your audit this year, the impact. And so yeah, who knows yet, because Department of Audits is still working that out. I will say there's a lot of resources out there to help you on that, and we be glad to provide you some support on that. YAS is really good with that as well. They have some resources to help you on that, so don't hesitate to reach out to them as well about some reports that they can do for you so that transparency piece is clear. So anything else you want to add on that?
No, I just want to say thank y'all for giving us the opportunity to kind of sit here and just sort of talk about a few things that are interesting for us.
Here at the fine video studios in Pioneer RESA. Y'all saw this high class studio we have here. It's always a lot of fun when we get together. Cory won't do stuff in his office. He has to drive all the way up here just because he loves our studios so much.
That's right. But I do want to thank Gavin, Terry, and Yoss for sponsoring this. And if y'all have additional, as Tim said, if y'all have additional ideas, we're happy to look into it. If that's something that would help y'all, we're happy to do that as well. So with that,
we are absolutely planning a finance QBE one coming up in a couple months. So anticipate that one coming.
all right. Well, thank y'all very much. I hope you have a good rest of the day.
Have a good one.
Thanks, guys.